The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
And I expect everyone's already seated. I'm used to hearing that. All right, I'm gonna docket. This is case 20J443, Commonwealth versus Eugene Sutton. I'm gonna say something in the beginning and tell you all you're gonna be welcome to using your 15 minutes however you like. It's your time, but I wanna tell you what I'm thinking. Two things. I don't see it as a Rule 6 motion to stay. Because it seems to me that the effect of that would simply be to stay the order denying credit for time served. It is a matter that I can't decide finally. It will go to a panel. But it seems to me that it's really more controlled by Rule 6. Can do this. And the Rules of Criminal Procedure, Rule 30C for post-conviction procedures 8, that it's an appeal from the Judge Roach's order denying credit for time served, if I've got this right. And Mr. Sutton believes because he should have credit for time served, he should be released. In the interim, I could release him on bail, as I understand it. And the other piece is that I'm going to ask Mr. McKenna to address is if you got a 19 to 20 in 2011, how would you get out this soon, no matter what we did? I mean, it seems to me that that would be something that could wait until after the court, even if he's entitled for credit for time served, picking up 900 days. I don't know how that gets you out. So I think you're first, Mr. McKenna.
Thank you very much, Ryder. And thank you for letting us have this hearing. And thank you for this format. I remember being stuck in the pike on the way to the appeals court in the past, and that was no fun whatsoever. This is far better. In terms of the court's concerns, I had the exact same one relative to how possibly being sentenced at that time could get him out now. This was before truth in sentencing. This was an old case, and therefore the old rules applied.
Parole eligibility after 12 years then.
My understanding is the caseworker has established that, in fact, October 13 would have been the release date. If the credit was given.
All right, and that's how you get to 12 years from 2011. No, but why wouldn't that be? All right, go ahead. Tell me why. I understand that the caseworker, I looked in vain to figure out how the caseworker came to that conclusion, and I don't see it. He was sentenced he was first held on this in 2011, right?
Yes, right. Yes, right. And
so, and it's a manslaughter, right?
Yes, 19 to 20, exactly. Yeah.
So you get 12 and change, right? 2/3 parole eligibility, because it's allegedly committed before in 1989, right?
Yes, sir. Yes.
Whatever.
And
so why isn't he not eligible for another couple of years? I could order it expedited by the panel. You could get a decision before he was parole, if they agreed with you, and they might very well. I think of course, hear from Ms. Delator or Mr. Pollenbaum, whoever's going to say, I think got a pretty good argument, but I don't see how that gets you out before 2013.
My understanding is based on the 12 years minus the good time. He would be hitting that time now, given the fact that it would be 10 years, I'm sorry, from 2011 till now, we're moving up on 10 years from the date he was first held on this.
9.5, right? We're talking May, as I got it, right?
Exactly, Your Honor. Exactly. Or March. It's my understanding that this calculation would put him out now. And that's something the caseworker has calculated using the magical calculations they use, based again upon the truth and sentencing sentence. And
But you'd still have to see the parole board, right? But that, he doesn't just get out unless I let him go on bail. You'd have to go before the parole board, right?
he at some point would go to the parole board, and I expect he would be on the parole for quite some time. The key here is
Assuming the parole board paroles you, which is, they ain't doing a whole heck of a lot of that.
right. The only other factor would be that he's at Norfolk, MCI Norfolk, and there is a great deal of COVID down there now. That's not in our pleadings, but my understanding is that's running amok there now. To the extent that it would apply at all. My understanding is dozens of people have it there now. Again, that's not part of our pleadings. That's brand new.
Doing these cases, so I've been looking at the special master's report on a regular basis. That would be another issue. That would be a change in circumstances, which I can look up. I can get that pretty easily.
Thank you.
All right. Is there anything else you want to say that you didn't get a chance to say?
In terms of, I'd like to address the court's other concern, if I may, and that was the procedural aspect of this. We brought a motion to stay below, and that was denied.
But what is it you wanted to stay?
The sentence on the manslaughter, the running of the sentence on the manslaughter.
But he's already got that sentence. He's serving that sentence. I don't have any authority to, you don't have a motion for a new trial, and you don't have a motion for any kind of appeal except from that order. And the only thing I could stay is the effect of Judge Roach's ordering, saying, no, you don't get the credit. I don't think that helps at all.
There's a second appeal here. There's this one, and there's the appeal directly from the denial, and which is a separate appeals court docket number.
Either way, staying them doesn't get you anywhere, right?
We would suggest it could, because of the court's inherent power to stay a sentence under the rules and allow this to go through the courts. If his release date was October 13, and by the time we get all the way through the appellate courts, it could be next year. It would be next year, and perhaps late next year. And if he spent from October 13 until July or August of next year incarcerated, that's just a travesty, where he should be out.
I just think it's a different vehicle. I mean, I think it could be done, but I think it's a Rule 30, not a Rule 6. But
Thank you, Your Honor. Your Honor, if we would defer to the court's understanding in that regard and suggest that if it's possible, in the interest of justice, to allow Mr. Sutton to get out now, whatever rule the court would deem appropriate, we would be entirely on board with. It's just that, given the fact that he had 929 days, which we would suggest should be applicable in this case, his sentence should be reduced by that amount, because it was not in an unrelated matter. It was in this matter, where he's held as of the arraignment. In our documents are.
No, I know. I saw the minimus.
Thank you, Honor. Thank you, Honor. And so he's held on this. The case law the Commonwealth has pointed to is sound. It talks about how you can't use dead time in an unrelated case. We don't dispute that. What we do dispute is the fact that that case law doesn't apply here, because he's not. The cases they cite, the Bond case and the Holmes case, go back to the idea, in both of those, there was an earlier conviction that was vacated, and the defendant tried later, after being convicted subsequently, to come back and say, well, I've got a couple years from a prior sentence, which is dead time. I'd like to have this new sentence reduced. The court said no. Most reasonably. There are exceptions to that which don't apply here, but the rule is something we don't contest. We just say it doesn't apply.
And these days, though, if the drug case had not been dismissed, right?
Right.
If Ms. Farrak had not been the chemist,
Right.
he wouldn't get double time, right? At least these days. In the olden days, if it was on the mitt, you get credit no matter what. But you don't get double time now, right? It's just that
Wouldn't-
that case went away.
Exactly. So the only thing he was held on since 2011 was this case. And
Well, he was held on the drug case. It's just that that's going away now.
exactly
Right.
right. And that brings us to the Manning decision, where they looked at exactly this type of situation, and the court deliberated back and forth and said, where there's an intervening sentence that goes away, the statute at issue here, 128B, should apply as respectfully the defense is suggesting now. It shouldn't be a question of saying, well, we're not going to let the other time apply. Nope. The court, and if I can just read from Manning.
I have it in front of me. You want to tell me what page?
Thank you, Your Honor. It's on 396. And it's the paragraph that starts finally. And that paragraph ends in a few sentences I would read, but Your Honor is far better at reading those than I would be trying to read them from a page. Where there's intervening sentence and it goes away, under Manning, you credit the time as though it wasn't there, which is exactly where we are in this case. And that is our argument, which brings us back to the idea that if he's held, as we make that argument, as we go through the appeals court, to the process, and he's being held, and they say next year, next fall, that he's right, he's entitled to get the time, and he can go home. He spent a year, but he can't get back. And that goes to the security argument. Our argument on security is that there is no legitimate interest by the Commonwealth in keeping him in jail longer than he should be, which folds back into the idea that under Manning, under Manning, he is entitled to apply this time against his sentence. And that's where we are.
All right. And if I thought you were right, and if I made a decision to release him on bail pending, if I did, what would we be talking? Are there any conditions of release or anything that you think he could make that would be appropriate?
Under any conditions the court would care to impose, or any court would care to impose, would be fine. My objective is to have him home with his family for Thanksgiving. That's all.
Right.
Whatever conditions would be applicable would be perfectly good with the defense.
All right. Did you get a chance to say everything that you wanted to say?
Yes, Your Honor.
All right. Ms. Delatorre or Mr. Pallenbaum, whoever's up, please, if you would.
Good afternoon, Your Honor. Monica Delatorre on behalf of the Commonwealth, and as you mentioned, with me is ADA Ian Pallenbaum, who is the trial prosecutor in the underlying Suffolk County case. I'll start with your first question, which is regarding whether you can actually rule on this motion for a stay of a sentence. And I would suggest that it actually cannot be ruled upon because the defendant is not challenging the underlying conviction on appeal and not challenging the constitutionality of a sentence. I would point
what about Rule 30? You look at 30, I have to do some research, but Rule 30 C, post-conviction, right? An appeal from a final order under this rule may be taken, under 8, right? So Rule 30 of the Rules of Criminal Procedure, C, post-conviction procedure, and then 8, and it says, as I read it, for the most part, it's not, if the final order grants relief other than a discharge from custody, the trial court or the court in which an appeal is pending may, upon, well, it says interesting, that says the Commonwealth. There we go. If the appeal is taken, the defendant shall not be discharged from custody pending final decision upon the appeal, provided, however, that the defendant may, in the discretion of the judge, be admitted to bail pending decision of the appeal. Right? I can't decide, right? I think this goes to a panel. And I can order it expedited if the Chief Justice agrees, but I can't, and I could arguably, I could arguably release him on bail pending. And I'll hear you on whether he should even get the credit, but I think you got an uphill battle there, just to be honest.
Right. I do not think, I will have to think about this further. I don't think this court can grant bail. I think for the same reason that it couldn't rule on the motion to stay. I think that decision would lie within the executive branch. And so for the same reason that it couldn't rule on the motion to stay, I don't think this court can grant bail.
Well, it says, provided, however, that the defendant may, in the discretion of the judge, be admitted to bail pending decision of the appeal.
But I'm not sure this court could grant bail post-conviction.
Except that it's under, I understand I'm throwing this at you out of left field. That's why I wanted to start. But I have to say that Rule 30 is post-conviction relief and 30C is post-conviction procedure.
Apologies, Your Honor. I still think so. I mean, I still think that the underlying conviction would still need to be for Rule 30C would still need to be a motion for a new trial that's challenging the conviction in this case for that to apply. Because otherwise, without that, it wouldn't be within this court's inherent power to do so. I think.
What if we didn't have any debate about whether he was right or wrong? In fact, he gets the credit, and I'll hear you on that, but I think you get a pretty good argument on that. Right? He was held on the MIT. Let's do that one first. He was held on the MIT, right?
I would disagree that he was, well, I'm sorry, apologies, Your Honor.
No, go ahead.
I would disagree that these are related sentences and that he was held on the MIT. He was being held in Middlesex County at that time, serving a sentence in Middlesex County.
He was also held, like, I got to tell you, you know what my background is. People used to say to me, can you put $25 on the other case, Judge, so he gets credit for that too? And I would say, no, because I didn't want him bailed for $25 and them to miss my $25,000 on the real case. But the understanding always until Manning was that if it was on the MIT, you get credit for it. And he went out on him. At the same time, he was, I agree with you, held in Middlesex, doing time on Middlesex, but there was a minimus holding him without bail on murder all that time. And you can have two sets of process, right, going on once. That's why, you got to have as well as MIT. Right?
I would agree with that, though I would suggest that under Manning and also Commonwealth versus Barton and Pearson, that when a defendant is confined pursuant to a sentence for here being an unrelated crime, which these crimes weren't related, they're not being held in custody awaiting trial. They're not able to use it for both of those ways.
Notwithstanding that there's a minimus that says you're held on that. In fact, held on that without trial.
Correct, because where the defendant wasn't in Nashua Street and the minimus wasn't executed, it's also clear from the Habes that he was coming in from Middlesex County.
Right, no question. But that's now dead time, right?
The time in Middlesex County, excuse me, I would say it's technically dead time because the time has been vacated, but because these are unrelated crimes, the sentence, the time that was.
I hear you. I'm sorry, and I'm interrupting you too, but that's okay. I think this is productive. The cases that talk about you can't bank it, this are for a subsequently convicted time. You can't say, hey, I know I got the 2 years they owe me, so I get a free pass. I can sell drugs in the school zone, for example. This is a murder that allegedly occurred before the school, before whatever gave rise to the drug case altogether. So there's no question of banking, right? Or any, whatever he did with the stabbing is not he can't have done it in anticipation that he could bank, right? It has nothing to do with that, right?
That he was banking time. Well, the prohibition against banking time still applies even if the timeline is as we've said here. That's under Commonwealth versus Bond and the Duking cases, where that time.
Those were subsequently committed crimes, right?
Correct.
They were,
That's
right? They weren't, you know, it wasn't like you got out and then you committed a crime, but they were crimes that were committed after the one that, you know, that got vacated, right?
That's true, though under Bond, there is it's on page 901 to 902, it discusses that even where the second offense was committed beforehand, that prohibition on allowing.
Before what? Before the other sentence or before, because I read Bond and I think it was before the other sentence was imposed, not before the other crime was committed. You tell me if I'm wrong. And
well, I think it applies in both situations that there wouldn't be able to be a banking either before the crime being committed or before the conviction.
You see the distinction, right, between a crime that was committed before the one that was vacated and a sentence that was imposed before the one that, right?
Yes, though I do think that where Bond is discussing the time where the timing that a second offense was committed before the first conviction was reversed, it applies there. And under Holmes,
Say that again.
That the second offense being committed before the first, before the first conviction is committed, but also before when the first conviction was even vacated, it still applies.
Was committed, okay, but I see a distinction. It may not make a difference in the application, but at least arguably I see a distinction between the crime that was committed before the drug case and the question of the, you know, order of the sentences. I mean, I'm not going to decide this in the end anyway, because I'm just the single justice. It's going to go to a panel and they're going to decide it. So maybe, right? Do you want to argue back about how he gets out after 9 years on a 19 to 20?
So my understanding, and we had just spoken with the Department of Corrections before coming onto here, is that there is a calculation of good time so that he would be, if the calculation of time between the arraignment and the plea date is correct, that I do believe he'd be eligible for immediate release. And that would have been the October 13th, 2020 date. So I do think that is correct.
Okay.
I would note for the motion to stay at the trial court that none of that calculation is provided in the record. And so if this, as this court, as you know, is looking at an abuse of discretion for the denial of the motion to stay, this court could affirm that.
Yeah, no, but you can look at the docket sheet and get the dates. I looked at the dates and we calculated. I think the dates are probably dead on. We're pretty close, right? From arraignment date. Even it's Superior Court arraignment. I don't know if he was arraigned in district court, but I checked. It's a Superior Court arraignment, so it's held on the bail that he was held on in 2011. All right, so that's interesting. I didn't even know. Yeah, because the crime was committed before truth in sentencing, not the sentence, right? All right, well, that's correct. That was one of the reasons we had this hearing. Any problem if we wanted to order this if I got to deal with the bail issue, and I would hear you on that. But any problems with expediting it and doing it sooner rather than later so we can move it along and get a panel decision on that?
Expediting a decision for it going to the full bench, I don't see an issue with that, no. In regards to
the full bench, you only get 3 at a time. You know, we don't do the whole, right, in the appeals court.
I understand, yes, thank you.
Okay, fair enough.
Yes, I understand for it being a panel. Yes.
I know this is not your first rodeo, but you know.
No, I appreciate that. As far as whether this court could provide bail. My understanding is this is not a type of Rule 30 post-conviction motion where that could occur. I guess I would go back to my original argument that this is not a Rule 30 type of motion where the defendant is challenging the underlying conviction here. So I don't think that would apply.
All right. I mean, there is an argument that he's unlawfully restrained. Shouldn't there be, let's say he'd already done 20 years on this sentence, right? Let's say, right? And there was no question he was supposed to be out, right? I understand your argument, but, and you may be right. The panel may agree with you, depending, but let's say we all agreed he was supposed to be out. Shouldn't there be some remedy?
Well, I don't believe so because I don't believe the sentences are related to one another. So
All right, but
you
you can't fight the hypothetical. I understand. Lawyers do that and so do judges. If we all agreed, right? Let's say it was 20 years after he got this sentence, period, the end. For some reason, it was all screwed up and nobody wanted him out just because he was a really bad guy. And this is a hypothetical, Mr. McKenna. I'm not talking about your client. I don't know him. There ought to be some vehicle to get him out, right?
I think that principle of fairness, though, is what Holmes and Bond speak to. They've sort of have discussed that it may seem like there may be an element of dead time, but in equating that and looking at between that and fairness and the possibility of banking time, it's looking at those two balancing those two competing interests that a defendant still can't use that time on a subsequent sentence.
Yeah, I understand that argument, and you may be right, and the panel may agree with you, but I'm coming back to what Rule 30 says is any person who is imprisoned or whose liberty is restrained pursuant to a criminal conviction may, at any time, as of right, file a written motion requesting the trial judge to release him or her or to correct the sentence then being served, that a motion to release, arguably, right, upon the ground that the confinement or restraint was imposed in violation of the Constitution or laws of the United States or the Commonwealth of Massachusetts. Isn't that what he's done here?
I don't believe so because he's not challenging this as an unlawful restraint. He's not challenging the underlying constitutionality of the sentence.
File a written motion, the trial judge to release him or to correct the sentence then being served, right? On the grounds that the confinement is imposed in violation of the laws of the Commonwealth of Massachusetts, which is what he's doing, right?
Well, I don't understand the defendant's motion as being challenging the sentence that was imposed in terms of it being an unlawful restraint and the constitutionality of the sentence.
Right. What he is saying, he isn't challenging the sentence. He's saying to release him or to correct the sentence. Those are right.
Well, a motion to correct the minimus, the jail credit, but not a motion to correct this.
All right. I don't. It won't. There isn't any point in my beating you up to try to get you to agree with with my framing of the issue. So I would suggest and think about it in if when you're doing your appeal that the motion to what he's filed is a written motion to release him and not a motion to correct the sentence, because those are disjunctive. And that's what he's saying is, let me out, I've done my time, is what I understand it. Now how the panel interprets Holmes and Bond and Manning and all of that is going to be for another day. But I understand, I believe your argument that this isn't what that is, but.
That is my argument, Your Honor, that is a motion for jail credit and not a motion for an unlawful restraint, or arguing that it's an unlawful restraint.
Okay. All right. So is there anything that I've asked a lot of questions and not given you a chance to talk much. And if there's something that you want to say that you didn't have a chance to say, I'll be glad to hear you. Or if Mr. Pollenbaum wants to jump in, he's he's filed a lot of this stuff already. So anybody want to say anything he didn't get a chance to say?
Only on the issue of bail, assuming you reach that, Your Honor.
Okay, Ms. Delatorre, is there anything you want to say that you didn't get a chance to say?
No, I would just reiterate, Your Honor, that it is our position that it's currently not appropriately in front of this court. And I would just note, as well as we've noted in our filing, that the defendant did have a pretty significant criminal record here. And in terms of the consideration that he is a flight risk. Notably, he was serving a violation of probation when he was indicted on the first-degree murder case in Suffolk County. And I would also just note that there was no indication that this was a COVID type of motion. The defendant did not provide a plan of release here.
Right.
Thank you.
I don't know anything about medical conditions or anything like that.
That is
All right,
correct.
Mr. Palmer, you want to say something about bail? If we get there, I don't, I got to think about all this, but.
If we were to get there, Your Honor, I think the argument against bail would simply be that, and part of it has to do with incentive to return to court. Obviously, we take a different view than Mr. McKenna of the strength of the underlying claim for jail credit. The Holmes and Bond cases and the other ones talking about specifically Dukan reversals. Those all came after Manning. I think Manning was 1977. And it takes some effort. I think I understand the logic about, well, you're not trying to deter somebody from committing a future crime, but the courts have still said that it has to be either actual innocence or some other compelling circumstance. And they've specifically said with regard to Dukan cases that the Dukan reversal is not a compelling circumstance. And I think that factors into the likelihood of success and therefore the incentive to return. And then you have somebody who is serving time on a homicide conviction that was an agreed plea to the maximum for manslaughter. And the backdrop before he got that sentence was a significant record, even if you take away the Middlesex drug case that was vacated. And based on all that, I suggest he would be inappropriate for release on bail.
All right. Well, thank you all. I appreciate it. This has been very helpful. I can't hear you, Mr. McKenna, if there's something you wanted to say. We don't usually do a rebuttal, but this is a little unconventional anyway.
Thank you very much, Your Honor. The only thing I would add would be that if he's done his time, and it's very much to the Commonwealth's credit that they tracked that down. And if he has done his time as October 13, if assuming it prevails eventually prevails on the credits issue, there's not really a question about his return. If he's done his time, there's no risk of flight. He's not going anywhere. That's the only point.
I don't know. He might not want to sign back up to go back in. But anyway, all right. I hear you.
Thank you, Your Honor.
Thank you all very much. And I'll get this done as quickly as possible.